Hello and welcome to our webinar. My name is Dora Leonidou and I am a Junior Legal Specialist of Eltoma Corporate Services. The today webinar will focus on the corporate residence in the UK. We will firstly explain what the corporate tax residence is. Then we will examine under which circumstances a company may be considered as a UK resident. We will point out which tests can be applied in order to identify the corporate tax residence of a company. And the webinar will conclude by providing some guidelines that a company can follow in order to be treated as having the status of resident outside the UK. So let's start. What is corporate tax residence? It's the legal framework under which the taxing rights over the profits and gains of a company are imposed. The criteria of determining the tax residential status of a company are different from jurisdiction to jurisdiction, and each jurisdiction, of course, defines its tax residence based on its own criteria and according to its statute and laws. This creates a complexity in case where a company operates in more than one jurisdiction, in more than one country, and in such case, the company must be very, very careful in order to ensure that it will be liable to taxation only in one jurisdiction. And of course, for that reason, there are the double taxation treaties in order for a company to avoid the double taxation. Now, let's go to the corporate residence in the UK. A company which is duly incorporated under the laws of the UK is obliged to apply these laws, and it's subject to the UK corporation tax. However, there are some other occasions in which a company, although it is not incorporated in the UK, it is still liable to the UK corporation tax. Let's examine those occasions. First example. As first example, we can use a company which is not incorporated in the UK, but it is trading through a branch or agency, the so-called permanent establishment in the UK. In the case of permanent establishment, the company will be liable to corporation tax on the worldwide income and gain for this certain branch or agency. Now, what means permanent establishment? A permanent establishment has dual definition. It can be a fixed place of business or independent agent. A fixed place of business can be a building in which the non-resident personnel can use for non-resident business. And on the other hand, independent agent is someone who is dependent to the non-resident company and does business on company's behalf. Now, the mere fact that the company has UK customers, UK clients, does not mean that the company is trading in the UK. The difference in this occasion is that the company is trading with UK customers, but from abroad. It's not trading in the UK. It's trading with UK clients. Also, simply having a UK website does not provide accurate evidence that the company has a fixed place of business, a branch, or dependent agent. Important to take under consideration is that many businesses are groups of companies, and only some of the companies are operating in the UK. Let's give an example. We have a non-UK company who sells products to UK customers through internet, through its site. On the other hand, we have another UK company, this time, UK company of the same group, which provides warehousing or distribution of the products and generally provides support to the selling company, which is not a UK company. So we have two companies. The first company is a non-UK company and sells products to UK customers, and the second company is a UK company who supports the selling company. In this case, the corporate tax will be imposed only on the profits of the UK company, the one which supports the non-UK company, and the tax will not be imposed on the profits and gains of the group of companies. So the tax will only be imposed on the profits of the UK company. Another example is a company which, again, it is not incorporated in the UK, but it is liable to corporation tax because it has a UK source income. In this case, the corporation tax is applicable only to the UK source income. If the company has income from any other jurisdiction, is not subject of the corporation tax. Only the UK source income can be taxed. Now, in order to examine whether a company is a UK resident and therefore liable to corporation tax, 3 tests can be applied. Firstly, the place of incorporation. Secondly, the place of the central management and control. And lastly, the treaty override rule. Applying the first test, which is the simplest one, someone should examine the place of incorporation. Having in mind limited exceptions, very limited exceptions, a company which is duly incorporated in the UK can be automatically considered as a UK tax resident. Exceptions in this general rule are those companies which they are considered as tax residents of another country, of another jurisdiction, due to the tiebreaker provisions of a double taxation treaty. Applying now the second test, someone should focus on the place of the central management and control of the company. A company may not be incorporated in the UK, but it may still be considered as a UK tax resident if its central management and control is placed in the UK. So although the company is not incorporated in the UK, if the central management and control is placed in the UK, then the company would be liable to corporation tax. According to the Revenue and Customs, HMRC, the central management and control is always a question of fact. Specifically, in the majority of the cases, the central management and control is considered to be in the UK if the decision making and particularly the binding decisions for the company takes place in the UK. For example, if the board of directors meets and takes decision in the UK, inside the UK, then there is an assumption that the company is a UK resident. But is this sufficient? One need to be very, very cautious when reaches such a conclusion. Why? Because what if the board of directors directors does not exercise an actual or effective control. And what if the chairman or the managing director draws a specific decision, conclude a decision, and the other directors just follow that decision without exercising any actual control? This is the crucial point here, the autonomy of the board of directors. The power and decisions of the board of directors must be dependent from any third person's actions and or instructions. It is very important that we have a clear distinction between the decisions made after the supervision of a third party and those decisions that made after the exercise of the central management and control, irrespectively of any potential influence by a third party. Because if the third party does not control the company, or if the directors just delegate to the third party any tasks of administrative nature, then the board of directors retains the management and control, has enhanced the management and control of the company, and therefore this specific requirement has been met, and the company can be considered as a UK tax resident. Therefore, the mere reason that the company is not incorporated in the UK does not provide a convinced and accurate evidence of a non-UK residence if the management control is placed within the UK. So even if the company is not incorporated in the UK, if the management control is placed in the UK, then the company will definitely be liable to corporation tax according to the UK tax legislation. Now, let's go to the third test, the treaty override rule. The treaty override rule operates to reverse the outcome of the other two tests, the place of incorporation and the place of central management and control, in order to identify a company as a resident outside the UK. As a resident outside the UK can be treated a company which is regarded as resident of other jurisdiction, of an offshore jurisdiction, and there is a double taxation treaty in force. Very important, double taxation treaty in force. Consequently, if there's a double taxation treaty in force, then the tiebreaker provisions apply, and the company is considered as a tax resident in other jurisdiction, in this other jurisdiction, and not in the UK. In occasions now where a company falls into this category, but the tax treaty contains a provision for a dual residence, that a company can have two places of residence, then the company is treated as a resident in the jurisdiction in which the central management and control is placed, as analyzed in our previous point. So if a company has a dual residence, for example, both in UK and in Malta or in Cyprus, then the company will be tax residents in the country which its central management and control is placed. Now, there are some guidelines to follow in order for a company to be treated as having the status of resident outside the UK. Let's examine the first indicator. First indicator is the holding of physical board of directors meetings, actual board of directors meetings. all the meetings must be held in the offshore jurisdiction. It would be better if the memorandum and articles of association contains a provision prohibiting the board of directors to hold meetings in the UK, or even prohibiting the directors to vote whilst they are in the UK. And therefore, if the meetings are held outside the UK, then the company can establish that its business cannot be run from the UK for the mere reason that the meetings are not held in the UK. In the case that this option is not fully available, the company must show that those directors who participate from the UK have no determined control and they cannot influence in any way the decision-making process. Also, meetings of the board of directors should be held regularly and preferably in a quarterly basis. Now, a link to the board meetings are the board minutes. As per standard procedure, full and precise minutes providing accurate information on what it was discussed and decided during the meeting must always be prepared. Notice of the meeting, including a detailed description of the agenda and the business operation of the meeting, must be given to all directors in order to give them the opportunity to consider the matters subject to discussion. So the directors must consider any matter that it will be discussed during the meeting. This will provide accurate evidence of the fact that the directors have deeply considered and discussed carefully all the information provided to them before, of course, concluding to their decision. Retaining board meetings and any other relevant documents prepared for crucial decisions of the company will provide accurate evidence that the company is actually controlled and run from an offshore jurisdiction and not from the UK. Evidential information of directors' presence in the meeting can be air tickets, hotel bills, transportation bills, or any other documentation proving directors' presence in the offshore jurisdiction. In that way, the HMRC will investigate the actual attendance of the directors in the board meeting, and of course will validate the directors' locations, that the directors actually were in the offshore jurisdiction in order to participate in the meeting. Therefore, if there is a place outside the UK from which the management and control of the company is run and conducted, then it will be easier to establish and, of course, prove to the HMRC that the company is not a corporate resident in the UK. Second indicator is the decision making. All meetings of the board of directors held in the offshore jurisdiction must concern and affect the management and control, as well as the established policies of the company, such as business strategy, financing, marketing, expansion of company's business, like new offices, new products, new services. Appointment of managers, directors, officers, auditors, and other professionals, any agreement that the company will be entering into, and any transaction that the company will conduct. All this matter can be discussed in the board meetings, and the directors must be notified and must be informed in detail about them in order to take informed decisions. As already mentioned, the directors must have time to investigate further the proposed matters and all the information provided to them. And the important point here is that the director must get fully involved in the decision making process and be able to identify what is the best interest of the company. In order to do so, the directors need to independently take a decision and not following any guidance or instruction from any other person, either director or other person who is a UK resident. So, crucial point here is that the directors must not accept or follow any instruction given by a UK resident. They need to discuss each matter separately and in detail with knowledge of what they are discussing, and they must mean both discussion and the decision. Also, all past resolutions must be signed by all directors in the offshore jurisdiction. However, the fact that all directors have signed the resolution does not provide evidence of getting involved in the decision-making process. An accurate and in a timely manner given notice, a consideration of the matter proposed to be discussed, and of course in discussion during the meeting. All these can provide accuracy of the decision-making process during the board meetings held in the offshore jurisdiction. So what if you just sign a resolution? What is important is to consider what are you signing, is to have a knowledge of what are you signing, and consider all the information provided to you in order to conclude to your decision as a company director. This is the important point here, and not just a mere signature by the director. A third indication is the residential status of the directors. The majority of the directors, in particular of those directors who participating in the decision making and of course attending the meetings, must be residents in the offshore jurisdiction. Especially the directors with managerial duties, who of course play a crucial role in companies management and business operation, must be residents in the offshore jurisdiction. Ideally, all the directors, or at least the majority, but ideally all the directors should be residents in the offshore jurisdiction, and any UK resident director should not attend the meetings of the board of directors in any way, either physically or via phone or email or video conference. Definitely UK resident directors should not attend the meetings. For that reason, the HMRC possesses the right to witness the directors who claim that they are residents in the offshore jurisdiction, and the HMRC can investigate, firstly, whether indeed the directors have an offshore residential status, and secondly, whether they have full and accurate knowledge and understanding of the company's business activities and operations in order to be able to take determined decisions. This is the point that we mentioned previously. A mere signature is not enough, is not sufficient. The directors, all of them, must have full knowledge of the business activities of the company, of what they are signing, and what is the best interest of the companies. And in that way, they are able to take decisions for the company's future. Special consideration must be given if the chairperson of the board of directors has a casting vote. In such an occasion, the chairperson should definitely not be a UK resident. Why? The casting vote determines the result of a meeting and, of course, of the resolution. So, the chairperson must not be a UK resident. Another important point concerns the alternate directors. Which are the alternate directors? Alternate directors are those who attend the board meetings on behalf of the principal director, on behalf of a director who is unable to attend the meeting. So, this director is appointed to represent the principal director, and of course, alternate director should not be a UK resident. This will strengthen the company's position that in the meetings holding in the offshore jurisdiction, the board of directors is taking determined decisions and put those decisions into effect. Because, as already mentioned, there is a criterion that the directors must have a residential status in an offshore jurisdiction. So it's not possible for the alternate directors to have a residential status in UK. I mean, they must have the residential status outside the UK. Last point here is that the directors should not accept instructions from third parties who are UK residents, and of course, directors should not rely on such instructions in such manner, indicating that they concluded to a decision based on the given instruction. Exemption here is an advice given by a professional advisor, and director may consider and accept an advice given from a professional advisor, and because the professional advisor cannot influence the procedure, cannot influence the decision-making process, cannot dictate the decision, is just an opinion provided by an expertise on the proposed matter, on a certain matter. So, because of the fact that the advice from a professional advisor cannot dictate the decision, the director can follow such an advice. A fourth and last indicator is the shareholders' meetings and the registered address of the company. As it is the case with the board of directors meetings, shareholder meetings should preferably be held in the offshore jurisdiction's premises. Also, the postal address of the company must be in the offshore jurisdiction. And of course, all the company's records, company statutory documents must be kept there. In addition, the company must be in compliance with all legal and tax obligations imposed by the law of the offshore jurisdiction. Ideally, the company should obtain a tax residency certificate, because tax residency certificates declared officially, it's an official document declaring that the company is a tax resident in the offshore jurisdiction. And the tax residency certificate, in the majority of the cases, can give the solution to an investigation, and this is strong evidence that the company is a tax resident in the offshore jurisdiction. Lastly, it would be better if The company maintains a bank account in the offshore jurisdiction and, in any case, outside the UK. All the above provide strong evidence that the company is a tax resident in an offshore jurisdiction and outside the UK. However, you must always keep in mind that the above are only guidelines, and corporate residence always remains a question of fact. So it's based on each separate case, and the more evidence that the company has, the stronger its position is in case of possible investigation by the HMRC. So the company must ensure that follows all the above guidelines, holding its meeting in an offshore jurisdiction. All the directors must be residents in the offshore jurisdiction. So the company must have all the necessary evidence to prove in the HMRC in case of investigation that it's a tax residence in the offshore jurisdiction. This is the end of our webinar, and thank you very, very much for your attention and attendance. Now, some words about our company, about Eltoma Corporate Services. Since 2004, Eltoma Corporate Services has maintained a competitive position in the corporate market. For over 10 years, our clients have enjoyed the range of products and services we offer, which have given them opportunities for solving international tax planning issues, asset protection, as well as the promotion of goods and services for international markets. Eltoma Corporate Services offers solutions of varying complexities, from company registration, legal and tax assistance, to establishing and maintaining holding structures. We have office locations in Cyprus, Singapore, Russia, Ukraine, and Hong Kong. Eltoma Corporate Services aim to provide our client base with a personal, cost-effective, and efficient service. Our client base has substantially and internationally grown over the years, yet we still retain our core values of professionalism, cost efficiency, and personal service. Our corporate services include company incorporation and maintenance, banking and finance, bookkeeping and accounting services, tax planning, IT and website services, software for business, web and marketing services, legal services, immigration services, licenses and permits like visa or work permits. Also, Eltoma Group expanded to deliver custom recruitment services to support employers within the Cyprus market to select the best person in the correct job position. Moreover, Eltoma can assist in investing in Cyprus, in buying or selling property, apartment, house, or land. That's all. Thank you very much for your kind attention. Below you can see our contact details. Please do not hesitate to contact me personally for any inquiries or clarifications you may require. Once again, thank you and have a nice day ahead.